Assalamualaikum warahmatullahi wabarakatuh. Kami dari kelompok 1 Hukum Internasional kelas B, Fakultas Hukum UPN Veteran Jakarta. Di sini ada saya Kornelius, ada Yoshirio Emillio dan Herdandi Bagas akan mengadakan simulasi persidangan antara Pakistan dengan India dengan sengketa kasus atas nama Jadhav yang diduga sebagai mata-mata di Pakistan. Sidang akan dimulai. Ya, Mr. Presiden.
Please be seated. The audience is open to sit down. The hearing is open. The court meets today under Article 74, Paragraph 3 of the Rules of Court. They hear the observations of the parties and the request for the indication of provisional measures submitted by the Republic of India and Pakistan in the Jadhav case. For reasons which they have duly conveyed to me, the Vice Presidents and Judges, Tomka, Ben Nuna, and Greenwood are unable to be present on the bench today. India's application, dated 8 May 2017, instituting proceeding against the Islamic Republic of Pakistan, concerns alleged violations of the Vienna Convention on Consular Relations in the matter of the determination and trial of an Indian national sentenced to death in Pakistan, Mr. Kulbhushan Jadhav. To found the jurisdiction of the court, India relies on Article 36, Paragraph 1 of the Statute of the Court and on Article I of the Optional Protocol concerning the compulsory settlement of disputes, which accompanies the Vienna Conventions. I shall now ask the registrar to read out the decisions requested of the court as formulated in the application of India.
In the circumstance, India seeks the following reliefs. First, relief by way of immediate suspension of the sentence of death awarded to the accused. Second, relief by way of restitution of interregnum by declaring that the sentence of the military court arrived at in brazen defiance of Vienna Convention rights under Article 36, particularly Article 36, Paragraph 1, and in defense of elementary human rights of an accused, which are also to be given effect as mandated under Article 14 of the 1966 International Covenant on Civil and Political Rights, is violative of international law and the provisions of the Vienna Convention. And the third, restraining Pakistan from giving effect to the sentence awarded by the military court and directing it to take steps to annul the decision of military court as may be available to it under the law in Pakistan. The fourth, if Pakistan is unable to annul the decision, then this court to declare the decision illegal, being violative of international law and treaty rights, and restrain Pakistan from acting in violation of the Vienna Convention and international law by giving effect to the sentence of or the conviction in any manner and directing it to release the convicted Indian national forthwith.
On the same day as the filing of the application, India submitted a request for the indication of provisional measures, referring to Article 41 of the Statute of the Court and to Article 73, 74, and 75 of the Rules of Court. In that request, India states that the alleged violations of the Vienna Convention by Pakistan has prevented India from exercising its rights under the convention and has deprived Mr. Jadhav from the protection accorded under the convention. The applicant also submits that Mr. Jadhav will be subjected to execution unless the court indicates provisional measures directing to the government of Pakistan to take all measures necessary to ensure that he is not executed until the court decision on the merits of the case. India points out that Mr. Jadhav's execution would cause court decision would cause irreparable prejudice to the rights it claims. India further indicates that the protection of its right is a matter of urgency as without the provisional measures requested. Pakistan will execute Mr. Kulbhushan Sudhir Jadhav before the court can consider the merits of India claims, and India will forever be deprived of the opportunity to vindicate its rights. I shall now ask the registrar to read out the passage from the request specifying the provisional measures which the government of India is asking the court to indicate.
Respectfully request that pending final judgment in this case, the court indicates A. That the government of the Islamic Republic of Pakistan take all measures necessary to ensure that Mr. Kulbhushan Sudhir Jadhav is not executed. B. That the government of the Islamic Republic of Pakistan report to the court the action it has taken in pursuance of subparagraph A, and C. That the government of the Islamic Republic of Pakistan ensure that no action is taken that might prejudice the rights of the Republic of India or Mr. Kulbhushan Sudhir Jadhav with respect of any decision the court may render on the merit of the case.
On May 8, 2017, immediately after the filing of the application and request for the indication of provisional measures, the registrar, in accordance with Article 40, paragraph 2 of the Statute and Articles 38, paragraph 4 and 73, paragraph 2 of the Rules of Court, transmitted certified copies thereof to the government of the Islamic Republic of Pakistan. He also notified the Secretary General of the United Nations of the filing these documents by India. By a letter dated 9 May 2017, referring to United Nations, referring to Article 74, Paragraph 4 of the Rules of Court, in my capacity as President of the Court, I called upon the Islamic Republic of Pakistan to act in such a way will enable any order the court may make on the request for the indication of professional measures to have its appropriate effects according to Article 74 of the Rules of Court. A request for the indication of provisional measure shall have priority over all other cases. Referring to the extreme gravity and immediacy of the threat, India asked the court to render an order on its request without a hearing. The court decided to hold a hearing in order to allow both parties to present their arguments. Given circumstances, the court decided that the oral proceeding conducted in Article 74, paragraph 3 of the Rules of Court should be brief and held on rather short notice. On May 15, 17, on 15 May 2017, today, I note the presence before the court of the agents and counsel of the two parties. The court will hear India, which has submitted the request this morning until 11:30 a.m., and it will hear Pakistan at the same time. The hearings on India request for the indication of provisional measure will be closed at the conclusions of this afternoon session. For the purpose of these oral arguments, each of the parties will have available to it a full 90-minute sitting. India may, if required, avail itself of short extensions this morning. In view of the time taken up by the opening part of these oral proceedings, the parties are of course not required to use full amount time allotted to them.
Introduction. 1. Mr. President and honorable members of the court, it's a great honor for me to appear today before this august court on behalf of the Republic of India as Indians again. At the oral hearing on India's request for the indication of provisional measure in the proceeding instituted by India against the Islamic Republic of Pakistan on 8 May 2017. This case concerned an Indian national, Mr. Kulbhushan Sudhir Jadhav, who has been awarded death sentence by a military court in Pakistan in egregious violation of the right of consular access guaranteed by Article 36, Paragraph 1 of the Vienna Convention on Consular Relations of 1963. 2. At the outset, I would like to thank the court and the President for the timely decision and action to exercise the power conferred upon him under Article 74, Paragraph 4 of the Rules of Court and send an urgent communication on 9 May 2017 to the Prime Minister of the Islamic Republic of Pakistan, calling upon the government of Pakistan to act in such a way as will enable any order to court may make on India's request for the indication of professional measure to have its appropriate effect. 3. Mr. President, member of the court, the fact that hearing is taking place today within 7 days of the institution of proceeding by India is testament to the recognition of the urgency by the court in the case of an innocent Indian national, Mr. Jadhav, who incarcerated in Pakistan for more than a year on consecutive charges, deprived of his rights and protection accorded under the Vienna Convention, being held in communication without contact with his family and the home state, is facing imminent execution. All nations of human rights now considered by the global community as basic to behavior in civilized nation have been thrown to the wind. 4. By this timely action by the President and the Court, this institution has provided succor not just to India and not to its beleaguered national and his family, but also has given hope to 1.25 billion people of India and hope to the old mother and father of the innocent Indian national that justice would be met out to their innocent son by this highest seat of justice and precious life will be saved. 5. Today, accompanied by my colleagues, I appear before the court on behalf of the Republic of India with the hope that the court would indicate professional measure so that the death sentence which has been awarded to Mr. Jadhav through a physical trial in a Pakistan military court, in violation of the rights guaranteed to Mr. Jadhav and India under Article 36, Paragraph 1 of the Vienna Convention, would be set aside and not carried out pending final decision of the courts on India's application. Briefcase 7. I will now present briefcase of the case, which will be further elaborated upon during the hearing. 8. India was informed on 25 March 2016 that an Indian national was allegedly arrested on 3 March 2016 India. On that very day, sought consular access to the site individual. The request did not evoke any response. On 30 March, India sent a reminder reiterating the request for consular access at the earliest. Despite a number of such reminders for consular access sent by India, there has been no response and all these requests fell on deaf ears. 9. Meanwhile, on 30 January 2017, India received from Pakistan a request for assistance in the investigation process. Subsequently, on 2000 March 2017, almost a year after India's first request for consular access, Pakistan formally communicated to India that consular access to Mr. Jadhav shall be considered in the light of Indian side response to Pakistan request for assistance in investigation process. India responded that consular access would be an essential prerequisite in order to verify the facts and understand the circumstance of Mr. Jadhav present in Pakistan. 10. On 10 April 2017, India learned from press report that Pakistan proceeded to have military trial against Mr. Jadhav, and he was sentenced to death purportedly on the basis of a conventional statement, and that this sentence was confirmed by the Chief of the Army Staff, Pakistan. Ironically, later in the day, 10 April 2017, after the death sentence had been awarded and confirmed, India received a note verbal from Pakistan reiterating the condition for considering consular access in return for India providing assistance in the investigation process. India responded the same day, highlighting that the offer of conditional grant of consular access after the award and confirmation that sentence reflect the physical nature the proceeding and so-called trial by a Pakistan military court against Mr. Jadhav. Despite requests by India, Pakistan has not provided any information or document, including the charge sheet proceeding of the court inquiry, the summary of evidence, the judgment request for appointment of a defense lawyer for Mr. Jadhav has also not elicited any response. The mother of Mr. Jadhav, even in the absence of any document, submitted on appeal to the Court of Appeal and petition to the federal government of Pakistan. This appeal was filed even though it was unable to address any of issue that might have been put against Mr. Jadhav in the judgment and order of conviction. It was an act desperate by grieving parents. The parents of Mr. Jadhav applied for visa on 25 April 2017 to travel to Pakistan. There has been no response. The Minister of External Affairs of India has written to the advisor to the Prime Minister of Pakistan on Foreign Affairs on 2017 April 2017 for his personal intervention in the matter, but there has been no response. All that we know is what we have seen in the media in Pakistan. The Pakistan officials have been reported as having said clearly that Mr. Jadhav would not be provided consular access. Mr. President, member of the court, India believed that the physical nature of the proceeding and unjust trial by a Pakistan military court in egregious violation of the rights of consular access under the Vienna Convention has led to serious miscarriage of justice. It is clear that Mr. Jadhav has been denied the right to be defended by a legal counsel of his choice. He has not been informed of his right to seek consular access. His conviction and death sentence appears to be based upon confession taken in captivity without proper legal representation and the absence of consular access sought by India. If we closely follow the reports in the media in Pakistan, we can get the sense that an increasing number of death sentences awarded by the military court in Pakistan have been carried out after 10 April 2017. That is when the death sentence to Mr. Jadhav was confirmed. In fact, over the past 1 month, such executions have been reported through a press release issued by Inter-Service Public Relations, the military spokesman of Pakistan. In such circumstances, including where there is no response to the request made through diplomatic channel, there is an immediate threat that the death sentence against Mr. Jadhav may be carried out even before India has the opportunity to be heard and the court has that chance to consider the merits of the case, and thus causing irreparable prejudice to the right of India and Mr. Jadhav. Request. Mr. President and member of the court, the Republic of India has invoked the jurisdiction of the court and sought professional measure. My colleagues will elaborate further on this 20. I would now request the court to invite Dr. V.D. Sharma, co-agent of the Republic of Indonesia, to make his submission. Thank you.
Merci, Monsieur. And I call upon Dr. Muhammad Faisal, representative of the Islamic Republic of Pakistan. You have the floor.
Thank you, President. Your Excellency, the President of the International Court of Justice, honorable judges of the court, Excellencies, ladies and gentlemen, I'm honored to appear before this court as Pakistan's agent and to make the following remarks. The delegation from Pakistan includes Ambassador Muazzam Ahmed Khan, the agent, myself, Mr. Hawar Qureshi, our consul, Barrister Asad Rahim, Deputy Consul Mr. Joseph Dyke, the Assistant Legal Counsel, and Mr. Faraz Zaidi as a counselor. Mr. President, I will provide a brief overview of the response of Pakistan to this application and then invite our consul Mr. Qureshi to develop the submissions as to why this application is unnecessary and misconceived. Mr. President, I am compelled to observe that whilst we share so much with the applicant state, we are on very different sides today. For our part, we wish that we are not so. Moreover, for our part, we wish to make it absolutely clear that we remain committed to the path of peaceful resolution of all disputes, whatever the provocation. Having faced the evil terrorism on a daily basis, with Delhi attacks only last Friday, killing 26 people and another killing 11 people on this other day in the area where Commander Jadhav was operating before his capture. We know only too well how to poison of hatred is used to achieve political ends by others. That is why, despite being induced into appearing before the court on a few days' notice, we are here. We are here because we will not be caught by terrorism, nor will we allow any attempt to malign or misrepresent our position or legal process to go unchecked. We will use all legitimate means to protect our people, our territory, and our reputation from attack, robustly and resoundingly, inshallah always. Unfortunately, India has in it fit to use the International Court of Justice as stage for political theater. We regret that this has been done. We will not respond in kind. Our consul, Mr. Qureshi, will explain why it was wrong for India to invoke the exceptional provisional measures jurisdiction of this court, the judicial organ of the United Nations. He will touch upon the reasons why the court should not otherwise exercise any jurisdiction or entertain any aspect of India's engagement of its jurisdiction. Indeed, it is somewhat ironic but perhaps consistent that India complains that it is not being given access to Commander Jadhav, who has confessed to having been sent by India to wage terror on the innocent civilians and infrastructure of Pakistan, and in the same breath has urged this court to make an order without giving Pakistan any opportunity to be heard. We are disappointed that India didn't take the opportunity to be transparent. Soon after 25 March 2016, when the Foreign Secretary of Pakistan protested in the strongest terms to the Indian High Commissioner regarding Commander Jadhav's criminal acts, India has been provided with a copy of the passport that was in the possession of Commander Jadhav when he was apprehended. You can see the copy of the passport on the screen there. Mr. President, as the court can see, the passport bears a Muslim name which plainly is not the name of Commander Jadhav. India has been unable, or perhaps more accurately, unwilling to provide an explanation for this passport, which is the most obvious indication of covert and illegal activity. India could simply have denied that the passport was genuine. We submit that India's silence is telling. Indeed, India could and should have responded to a letter of request dated 23 January 2017, seeking India's assistance to investigate the criminal activity and links with people in India, which Commander Jadhav has revealed. Instead, India appears to have been in hyperdrive mode to brief its press that Commander Jadhav, a 47-year-old man to look to early retirement and was kidnapped in Iran, from where he was brought to Pakistan to give a false confession, presumably. We fully understand that this court is not concerned at this stage with an evaluation of the merits. We are not sure that what merit there is in a state which sends as a spy terrorists seeking entitlement to untrammeled access to its tool for terror. However, we consider that it is important for this court to hear the extracts of the confession which were made public on 25 March 2016. On the same day, the P5 and the EU were also informed of Pakistan's grave concern in this regard. Indeed, later that day, extract of a video of the confession of Commander Jadhav were made public. I intended to share the extract of just around 6 minutes of the video with you now. I understand that the court has viewed the video, but would prefer it not to be shown here. I should make it clear that the video is publicly and readily available for anyone who wishes for it. The viewers can decide for themselves whether Commander Jadhav is convincing voluntarily and comprehensively. India will no doubt say that the candid and contrite confession was extracted by full means. That would, of course, be very wrong in every respect. Mr. President, India has sought to persuade this court that we intend to execute Commander Jadhav within days, despite India having selectively quoted from the contents of Annex 8 to its application. The court can see for itself that this is totally false, simply by reference to the clemency process available as a right to Commander Jadhav. A period of 150 days in this regard, which is even started on 10 April 2017, which is that of conviction as at first intents, could extend to well beyond August 2017. There is also, of course, the potential for the writ petition of the High Court to be invoked, as we believe India must be well aware. Pursuant to Article 184(3) and Article 199 of the Constitution of Pakistan, individuals have successfully obtained relief from the courts. India and Pakistan have a common source for the vast bulk of our legal process and procedures. More importantly, if the court will forgive my language, we simply have no reason to stop the canary from singing. Others might wish that we do not. 18. Just to make the point absolutely clear, an expedited hearing which would dispel any suggestion of the need for provisional measures is an approach that Pakistan would invite the court to adopt. On this basis, Pakistan would be content for the court to list the application of India hearing within 6 weeks. We have no desire to waste the court valuable time and resources in trying to score political points. Indeed, Mr. President, it is noteworthy that the Indian media widely reported your letter to the parties dated 9 May 2017 as a victory by means of it being a stay order, which plainly it was not. This surely is valuable insight into what really lies behind the maneuvering. I conclude, sir, where I started. Whilst we were bound into appearing before the court, it is always an honor to do so. The Islamic Republic of Pakistan cherishes the freedom which was gained 70 years ago and wishes to live in peace with its neighbors and hopes they will soon appreciate the virtue of such an approach. Thank you.
I thank the agent for the Islamic Republic of Pakistan. I now give the floor to Mr. Deepak Mittal, the agent of Republic of India.
Thank you, Mr. President and esteemed member of the court. I thank the court for their patient hearing. As the Council for the Republic of India has already read out of the request, I formally once again reiterate the request on behalf of the Government of India that pending final judgment in the case, the court indicate a. That the government of the Islamic Republic of Pakistan take all measures necessary to ensure that Mr. Kulbhushan Sudhir Jadhav is not executed. B. That the government of the Islamic Republic of Pakistan report to the court the action it has taken in presence of subparagraph A and C. That the government of the Islamic Republic of Pakistan ensure that no action is taken that might prejudice the right of the Republic of India or Mr. Kulbhushan Sudhir Jadhav with respect to any decision the court may render on the merits of the case. Thank you.
Thank you. That ends the oral observation of the Republic of India and Pakistan. So this brings the oral proceedings on India's request for the indication of provisional measures to an end. It remains for me to thank the representative of the two parties for the assistance they have given to the court by their oral observations. In accordance with practice, I would ask the agents both parties to remain at the court disposal. The court will render its order on the request for the indication of provisional measures as soon as possible. The date on which this order will be delivered at a public sitting will be duly communicated to the parties. As the court has no other business before it today, the sitting is closed. Thank you all.